And this matter comes before the court. I believe we are continuing a hearing regarding an allegation that there was a violation of the court's PPO. So, Mr. Murphy, would you put your appearance on the record, please?
Yes, Your Honor. Can you hear me okay, by the way?
Yes, I can.
Okay. Yes, Miles Murphy for the respondent, Paul Colby.
Very good. Thank you. And I do see Miss Angela Taylor present as the petitioner in this matter. Remind me, Miss Taylor, the prosecutor is not involved in this particular allegation.
No.
Okay, yeah, I don't recall the prosecutor being here previously. I just wanted to make sure I'm remembering everything correctly because, and I want to apologize to all the parties for the delay in starting today. The previous case involved a giant contract and other matters case with about 100 exhibits that I could barely keep straight in front of me this afternoon, and stayed up till 2 a.m. reading last night. And I'm already regretting that investment of my time, but it was totally necessary if I was going to get through this stuff. So that's what delayed me, was much longer at oral argument than I anticipated there because of the complexity of that case. So hopefully we're not as long today, but Mr. Murphy, where did we leave off last time?
Your Honor, we had a hearing about a year ago in February of 25. The PPO is due to expire. The PPO extension is due to expire on April 24 of 26. We are asking that PPO be that it go ahead and expire. We filed basically a denial of any violation of the PPO, and I think it's if the court looks at the volume of this PPO file, it is incredible how large it is. I think due to it's our position, this is a frivolous motion. It should be denied. We're also asking that the court recognize this as being kind of an ongoing, for lack of a better word, manipulation of the system. And really the focus here is the petitioner's displeasure with a Court of Appeals case involving the House, which is going to be.
That has nothing to do with this. This is for a PPO violation.
Yeah, no, I get it. I think Mr. Murphy's trying to say.
That's
Well, and
kind of
remind me,
wasting.
did Miss Taylor or well, let me finish with Mr. Murphy, and then I'll let you have a chance, Miss Taylor. Mr. Murphy, did we take any testimony during that last hearing, or did I just set a future hearing?
Sure. You did take a lot of testimony in February of 25, Your Honor, and then the other focus besides the House is the fact the parties have a almost 18-year-old son, and my client has sole custody, and I don't think the petitioner's happy about that either. So we ask that the
He doesn't
motion,
have sole custody.
excuse me,
I have
ma'am.
custody
Okay,
too.
yeah, no, hang on, Miss Taylor. I'll let you speak up. All right,
Reconnection.
Miss Taylor, I do recall now, and I'm paging through the file here, and it looks like I did take significant testimony about the allegations. Did I swear you in and have you testify last time?
Yes.
Your Honor.
Okay, and then Mr. Murphy cross-examined you?
Correct.
Yes.
Okay. Is there, I guess since this is your case, Miss Taylor, are there any more witnesses or evidence you want to provide at this time?
Yes.
Okay, who would you like to call?
Robert Goins.
Okay. And is Mr. Goins present? Is he with you, or is he separate?
Yes,
Is he gonna
he's
come
my
in?
tenant.
Okay. And is he on the same video as you are? Are you just going to switch it so he can testify, or?
Yeah, I can switch it. I can turn it around so you can see him.
Very good. All right. That would be good. Why don't you do that? I'll swear him in, and then you can ask him the questions, Ms. Taylor. Mr. Goins, would you raise your right hand, please? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
Thank you. And would you state and spell your full name for the record, please?
Robert Robert Goins, Goins.
Thank you, sir. And you don't have to keep your hand up anymore. Ms. Taylor, you can ask some questions of Mr. Goins at this time.
I just have a question a minute, Your Honor, if I may.
Go ahead.
This wasn't a trial hearing. I'm confused on why this has jumped to a trial when she was not prepared for a trial.
Well, I mean,
This was just a
I-
conference hearing on his PPO violation.
If I could respond briefly, Your Honor, I believe that it's teed up as a motion for an order to show cause for a violation of the PPO.
Yes,
And
correct.
so
well,
I
and
do
my
believe
sense
that-
was that I'd already inquired of Mr. Colby about this, that he pled not guilty, and that I
Nope.
set it for a factual hearing. And
No,
it
sir.
Oh, okay. Well, and believe me, I could be wrong on this because I handle about 1,000 cases at any given time, and to say that I have a hard time keeping them straight mentally, I'm completely dependent on my notes in the file here.
So, Your Honor, I
Okay.
think the focus is on several allegations about a February 12 of 26 Facebook posting. That's what Angela did not like. Is that correct, Mr. Goins?
There's several Facebook postings, stalking, where he's followed us to a library, and then posted it, where he's come to the home and he's making statements in regards to how many FedEx and Amazon comes to the home. That's showing that he's stalking. He posted that on Facebook.
So, Your Honor, they're all very recent allegations about conduct in February of 26 as allegedly violating the PPO, which is due to expire in a month.
I see. And so really what today's is simply the order to show cause, where I would obviously inquire of you and your client whether you wish to enter a guilty or not guilty plea, and then presumably set a future hearing to do the facts on this. In other words, I was about to skip a step.
Correct.
I think that's correct, Your Honor.
Okay, no, fair enough. Well, I take it, Mr. Murphy, from your previous statements, that your client intends to enter a not guilty plea to the most recent allegations of violation.
That is correct, Your Honor.
Okay, I will accept a not guilty plea in the matter, and I will set it for a hearing. Now, the bad news for you is the other consequence of these 1,000 cases I have is this hearing will undoubtedly occur after the expiration of the PPO. What's this? Well, I mean, first of all, how many witnesses, Ms. Taylor, do you think you're going to be presenting?
2.
Yourself and Mr. Goins?
And I have one more.
Okay, so up to 3. So I'm going to guess that's going to take us a couple hours by the time I give Mr. Murphy some opportunity to cross-examine and time for argument here. Wendy, this is a hard question. When's my next 3-hour block that I could set for a PPO hearing?
Well, we can do May 22nd at 2:30, but
Not as bad as I thought. Let's grab that time while it's available. May the 22nd at 2:30 p.m.
Also, Your Honor, Ms. Taylor also filed a renewal of her PPO that you didn't state anything on that as well.
Yep. No, I am looking here. Let's see. I see, boy, the violations and all the accompanying notices. Let's see here. I did get the. Oh. There's the extension. Yeah, and I did extend it. It looks like obviously back in April of 2025 to, as Mr. Murphy correctly pointed out, April 24th of 2026.
And then she just sent your office with the PPO office a renewed and got a document back saying that you stated that you would, after this conference hearing, or when it gets closer to that, expiration, that you would, then, state whether you were
I
going to
would make
grant
a
it.
ruling. Yeah, that's what I usually do if I have an upcoming hearing. As I said, you know what, I'll decide it all in one hearing. In this matter, because I'm not able to push that, what I'm going to do in this matter, since it's my schedule dictating here, is I will grant a temporary extension until that date of the hearing that I just sent, May 22nd. That's only 1 month from the expiration date anyways, and Mr. Colby has been obeying the order thus far, and then I will decide both the question of the extension and also, and I
I
apologize.
object because
Just that,
Mr.
ma'am, you're
Colby is,
interrupting.
Yeah,
Ma'am,
I
you're
don't have
interrupting the judge.
the extension just has not made its way into the request hasn't made its way into my paper file. It's probably in our electronic court filing system. I'm just flipping through the paper file that I brought home. When I get up to speed on this, I'll be able to review the extension. And then I think, I mean, my sense is I can decide that all in one hearing. Do you agree with that, Ms. Colby?
Yes, yes, I do.
If he comes
Yes,
on
Your
this
Honor.
property, I will kill him. That's that
Ms.
simple.
Taylor, do you think that I can decide that all in that single hearing in May?
No,
I don't know because he keeps violating his PPO. I have to be worried to even walk out of my house. I have to have somebody walk me out because he's constantly stalking. No, this needs to be addressed. He needs to be violated for this. If he comes on this property, he probably ain't gonna make it out alive because the cops take an hour and 45 minutes to get out here.
Totally disagree, Your
Well,
Honor.
yeah, I mean,
It
and
might be
my
because
only
you have
counseling
one.
to you on that, Miss Taylor, and I get
That
it.
Murphy really has
you know.
nothing to do
No,
with this PPO violation.
well, no, and he's representing Mr. Colby for the purpose of the PPO hearing here, and it's important obviously because Mr. Colby's the one, as I've explained to him in the past, who's at risk when one of these is in place against him, and if
Yeah,
you
and nothing gets done about it.
well,
He's
if you
already
all I can
violated
say is I have
14
and I was
PPO.
well, I have, and I believe there was one case in the past where I fined him a couple $100 on a violation, and I think what I'm
Oh,
hearing from
that's just
you
a
is
slap on his hand.
okay. Well, but nonetheless,
So if I come up missing, it's okay.
no, of course not. But that's not what's before the
Something needs
court
to
now.
be
So
done.
Your Honor, we'd
yeah.
ask that she be
Yeah, and here's the thing is right.
handcuffed.
What's done is
I'm
the
not talking
enforcement.
to you,
Yeah.
Mr. Murphy.
Yeah, is the enforcement of this thing, and I do want to mention to you, Ms. Taylor. Obviously, this isn't it's going to be a formal court hearing, and this is today as well, where we got to speak in sequence. It's not an argument per se, or us sitting at the table to hash something out. It's a very formalized and recorded proceeding where both parties have the right to appeal after I decide it. So it's important,
Your,
to
Your
do it
Honor, I just want to state to you
Mr.
that
Goins,
Ms.
I don't
Taylor,
want your statement because you're not a party, so you're out. So you just have to stay quiet. You want to file your own PPO? Go ahead and file it, but
He did,
you're
Your
not a
Honor. It
party
was
to the one
denied.
that's currently before the court. So anyway, that's what we'll do. We'll hold the hearing. The PPO does remain in place, and of course, parties are familiar with the terms of the PPO until such date that I will conduct a hearing. So I will see everyone on May 22nd.
Thank you, Your Honor.
Thank you,
Thank
Your
you.
Honor.
And this matter comes before the court today on the respondent's request to terminate a protective order that I granted. It looks like I granted it on March the 4th of this year. This case was brought by Ms. Gonzalez, so I will swear you in, Ms. Gonzalez, and have you affirm the basis, and then I'll hear Ms. Gamboa's response to that, and then I can make a ruling. So, Ms. Gonzalez, if you'd please raise your right hand. And you're gonna have to unmute as well. Okay, very good. And do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Very good. All right, Ms. Gonzalez. And you filed this protective order, which I granted, and the basis you stated in your petition was I see. She has been harassing me since last week, February 23rd of, I assume that's this year, 2026, and had threatened me with her firearm and threatened my family. Can you describe more specifically how that happened?
Yes. So, I had a confusion today about like the Zoom meeting. I thought this was gonna be in person, and I did have some evidence that like I wanted to present documentation of like statements that the respondent has said, and I think it's important for the court to review before like deciding whether to terminate the PPO.
Okay, and are those like printouts of text messages? What kind of documents do you have that you'd like me to see?
Yes, they're printed out screenshots of multiple messages that I received from the respondent. Yeah, I was gonna present them today, and I went to the court, but I was
Only
told
to
that there was
find
gonna
out the
be a
hearing
through Zoom.
was on Zoom. Yeah, I do all my PPO hearings on Zoom because the court rules allow me to. Either party, just for reference, can request to have the hearing in person instead. The truth is I can get a lot more of these hearings accomplished if I go on Zoom, so I prefer to do it that way. And sometimes it's easier for the parties than getting down to the courthouse and parking. But I am more than willing to do them in person. I guess for purposes of today, Ms. Gonzalez, can you? You need to come up with two incidents of threats that she made to you. If you can read out loud what she allegedly said to you during those messages, then I can let Ms. Gamboa respond to that as to whether or not she really sent the message or not, and then maybe I can get far enough to make a decision today. I may still need to have you come in. So, is it possible to read some of those?
Yeah, I have a total of 28 pages.
So it's a lot.
Um, yeah, it's quite a few.
Did you
But
submit
there
them to
is
Unveils or to the court ever? Because we do keep them.
no.
Okay, I was just thinking maybe I could pull them up if they were electronically in our file, but if they haven't, come through the door yet, then I won't have them available to me yet. Um, well, why don't you go ahead? And these are messages that came to you before you asked for the PPO um, on March the 3rd that were threatening. Do some of the messages threaten you with her firearm?
Yes, there was one message, and she said that I was going to get taken off the map, and also that she stated that she carries two firearms.
Okay, what's the date on that message, if you can tell?
These were in March 3rd.
Okay, same day you filed the request for the PPO, it looks like.
Yes.
And how do you know those are from Ms. Gonzalez?
Because she's messaged me through a personal account, and her name is on there as well.
Okay, so it says what is it says Jasmine
I
Gonzalez, or what does it say? Or I'm sorry, how do you know you're Miss Gonzalez? How do you know this is coming from the respondent, Miss Gamboa?
Is it okay if I can turn the camera around and
You
just
can
show
try
you?
that. Sometimes we can see it if you do it like that. Okay, I'm seeing what looks like a
Y-
printout, and you're saying it says right on the top there, Samantha Gamboa.
yes, that's Samantha Gamboa, and then this is the comment that she made. about threatening me.
Yep. And is that coming
And
in by
then
a text message to you?
yes, this is all these messages are through Facebook. And
Okay.
then here's another one where she said to be careful coming out of my house. And I have proof that she knows where I live, but I have never once told her my address.
Okay. And how do you know she knows where you live?
Because then she went onto my Facebook, and you can see here Samantha Gamboa commented on my status, and it says my address right here.
Okay. All right. So she, it appears in the comments on your Facebook page, wrote down your address.
Right. And she my pictures with comments about my address.
Okay. And taken in conjunction, where does she, where's the message that you said she sent you that said she carries 2 guns?
Right. This is right here.
Okay. And that says, love you should now I carry 2. Is that right?
Yes, I think she meant instead of saying now, she meant to say no. So love, you should know I carry 2.
Okay. All right. Well, all right. So, and what you're saying here to me today in your testimony is that um, the combination of those messages and her knowing your address created what you perceive as a threat.
Yes.
Okay. All right. Is there anything now you said you had some 20 messages there. Are they before or after the ones you just showed me?
So the ones that I showed you beforehand were back in March 3rd.
Yep.
Uh March, yeah, and then she's also just been posting my address all over social media.
I see. And what you're showing me now on the screen looks like it's dated March 3rd and it's the photo of a front of a house. Is it your house?
Yes, that is my house, and she's posted that on social media. And you can
And it
tell
says
here.
when you played too much, what is the next part of it? I can't quite read that.
It says when you played FBI too much, Stink needs a whooping.
Okay. And that again is originating, you believe, with Miss Gamboa going to you.
Yes.
Okay. All right. And it also occurred on or about March the 3rd when you asked for the order.
Um, um, I would also like to show you something very important, because whenever she has um served those papers right back to me, terminating them, she's also I've read the note where it says she's pursuing a nursing career.
Yep.
Um, and I would like to just put this out there that she somehow, I have no idea, found out that I was in Pine Rest hospital for a while. And if my sister, she told me that that's exposing my health information, and it's going against HIPAA regulations, which is made to protect everyone's health information. And
Did she mention the fact that she stated that you were in Pine Rest on this same exchange? I mean, is this on some of these messages?
yes, so she's also she's messaged me that right here where it says Pine Rest as ho. And
What's the date on that
after
message?
that, this was March 4th
Okay, so
at
after,
7.
yeah,
Yes, this
so
is
that'd be
after.
after you applied, maybe after she got served, after I signed it and issued the the order.
Mm, yes.
Okay.
And then she's also made a fake page about me impersonating me and putting my health information out to people to know, which that says here in the comments.
Okay, what's the name of the page that's impersonating you?
It's called Jazz GR Community 8.
Okay, and how do you know that
But
Gamboa made it?
right. So it says here, sorry. Mm, so whenever she's got served, which was 3/9/26 at 3:49 p.m. This is a confirmation picture of the PPO being served
Yeah,
and signed off. Um keep in mind that was on the 9th.
yeah.
And then this is the account that she made. She's had 522 followings and quite a like 56 postings of me. And the
Can
reason why I believe
can
that it
you
is
tell when
her
she
is
created, I'm sorry to interrupt, but can you tell when she created the page or the account?
no, that one I couldn't take a screenshot and print out, but um right after she's got served, I did receive a message from a friend of mine saying that the page did not exist anymore. And this was the day after she got served, which was March 10th.
Okay, so really you don't know for sure if she created that before getting served with the PPO or after, because you just can't tell from the Facebook page.
It was an Instagram page, but I'm more than confident to say that it was her because the comments that she made on all of these postings is something that she's already said to me in messages directly.
But you can't tell when she posted it. It doesn't have a date.
Um, like a posting.
Yeah, any date identifier, and it's important because the stuff that happened before is the basis for your protective order, and then things that happen after, if I continue the protective order, you can raise them as violations potentially, but they can't support the
Mhm.
protective order because they didn't happen until after I signed the protective order. So that's the importance of the date.
Right. This see this picture? This was on the 4th.
Okay, which would have been golly.
The same one she posted on that fake
Yeah,
page.
which looks like maybe she was served with this on the 4th because I think that's what the proof of
Yes.
service says. Yeah, okay. Well, that's the date I signed it, and right, she could have been served with it that same day. So, okay,
Mhm.
no, I think I understand what you're saying, and it sounds to me like what you're identifying the two threatening incidents, being those messages on the 3rd that say, "I think you should be taken off the mat. Uh, Stank needs a whooping, and I carry two." Those were the threatening messages in conjunction with her identifying your address that
Mhm.
that spurred you to get this PPO.
Yes.
Okay, all right. Well, let me give Ms. Gamboa an opportunity to respond. So, Ms. Gamboa, if you would please unmute and then raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right, thank you. And Ms. Gamboa, you respond to this asking me to terminate it. I
Correct.
apologize. Here I'm paging through the different filings and submitted a letter. And I take it from you, I'm reading down in your letter here. That prior to the incident, the petitioner communicated with me directly and provided her address, I take it, encouraging a confrontation. And that then, I mean, I guess what I'm trying to get, Ms. Gambo, is what's your version of what occurred? It sounds like from saying that maybe you're saying, well, she started it.
Your Honor, I take this situation very seriously. I understand the purpose of a PPO order. However, I believe the situation was a mutual and not one-sided. The petitioner also engaged and used aggressive communication and encouraged a confrontation. I provided you with evidence. I'm currently focused on my education and pursuing a nursing career as a nurse anesthetist. I almost didn't have time to make it today. My schedule is super busy with school and work. But yes, I did provide you with some evidence that she provided addresses and told me to come, and I did not go. So I believe that this was mutual. I've never seen her in person. I never met her in person. We don't go to the same places. We're not in the same circle at all. So therefore, that's why I asked for this.
Okay. Well, yeah, you're asking me to terminate it now, but you're not denying. Did you post the messages she cited about I carry two and mm, Stank needs a whooping?
Yes, I take responsibility for my part, but like I said, it was a mutual exchange. Um, Ever since then, I blocked her, and I don't have any intention in having further contact or arguing or doing anything of that sort. I just
Okay.
want to move forward.
Okay, and I take it you're saying that the confrontation, because what I'm looking at here is the documents that you submitted objecting, you know, and yeah, there's this page popped ass peasant. Are you saying is that your page or is that
No,
okay? You're saying that is
that's her.
her. Okay.
Yes.
And these are exchanges, and I'm looking here, March 2nd at 8:04 a.m. I'll be solo, pull up though, IDGAF, 3 p.m. Aha, never gave scary or pussy watch. Yeah, right. We'll see, fat F. You're a peasant. There's back and forth going, and I think what you're trying to tell me is that on March 3rd, when this conversation continues, it's simply an escalation or a continuation of a verbal or online electronic back and forth that had already been started.
Correct. But after that, like I said, we blocked each other. I blocked her, and didn't have any contact with her. And
Okay.
I was served. I know you guys were talking about that earlier, and I was served the 9th. I wasn't served that exact same day. I wasn't served the next day. I wasn't served the next day. I was served the 9th.
I see. So you didn't even know that there was a
No.
protective order against you until it was delivered to you. Yeah, it looked like I maybe signed it on the 4th. I don't have the proof of service here. Okay, all right. And
In your honor,
yep.
this is, like I said, this is very, very important to me because I mean, this is my career that I'm talking about. And in the heat of the moment, I was upset. But I learned and I grew from this experience. And it was a very tough time, but I don't want to go through it again, and nor do I want this on my record.
Yeah, no, well, here's the good news for you. These are civil matters. They don't ever show. The only time they would show on any government record is if the police run a lien check because they come to a call, alleging a violation of one of these things, they can see that the order exists. But when the order expires or is dismissed by me, whatever, it goes away. And unlike a criminal record, which is recorded by the state police in our, the database. This does not remain there forever. It's unlike that, in other words. And employers can ask you if you've ever been convicted of a felony, but generally they do not ask you if you've ever been subject to a protective order or things like that. And that's because they are civil matters. They are not as serious as a criminal matter. Now, I don't want to downplay it. If I put one in place and it stays in place, well, then you can get charged with a felony aggravated stalking for violating it, and it can get you in a lot of trouble. But the other piece of it is, even in a worst case scenario, when I grant these and they stay in place, and the reason I typically grant them for 6 months is recognizing that a lot of times, when people see these and legal documents start being exchanged, all of a sudden both people say, you know what, it's not worth it anymore, and kind of back away from the situation. And that may have happened here, and in that case, it kind of satisfied the intention of the order. So, and I hear what you're saying is, whatever you do, Judge, I don't want it to interfere with my future career aspirations. Where are you in that educational process now?
So I'm very excited to start in winter for my nursing program, and therefore I do need to submit a background check for that. That's why I'm like very, very, very serious about this. I do
Sure.
have a whole plan. I'm sorry.
No, no, and you said winter. I mean, so I'm taking it fall, next winter or this year?
Yes, next, like basically next year. Yes,
Okay, so in the fall term,
yes,
that would be when that would start. Oh,
correct.
okay, I understand. I don't think this is gonna even touch that because of its nature, but nonetheless, I do understand your concern. Let me return to um, petitioner um, in the case here, and
Okay.
hear from Miss Gonzalez again. Miss Gonzalez, um, you said you saw the letter. Did you see the attachments to the letter that under this Popdas peasant uh, um, web page, or not? It's a web page, maybe a Facebook profile. I'm not sure what it is. Uh, Apologize for my lack of social media currency. Uh, did you see those attachments?
Yes, I seen them all.
Okay, and I think what Ms. Gambo is arguing today is, look at Judge, I did say stuff that I now regret. However, it was in the context of this back and forth online. That what was a back and forth, and that it looks like you're responding here too, and uh, saying things back to her. What's your response to that?
So there was a point, um, where she kept messaging me and I told her to leave me alone. Um, and she kept going right after I said that. Yeah,
Okay,
so I told her that she was annoying me. Like at that point, she was just going to get ignored. And she then proceeded to text me after I blocked her on Instagram. This is Instagram.
okay.
After I blocked her.
And when you're saying this, you're referring to the documents that Ms. Gamboa attached screenshots of to her letter. Is that what we're all talking about here? This Pop Das Peasant series?
Yes.
Okay.
She then proceeded onto Facebook. So honestly, I don't believe that she would, not keep going after this because um she had only deleted that Instagram page because she found out that she was getting served with the PPO. Otherwise, she would have kept posting because I have a video recording of the entire page she made about me, and it says the dates and the timing. So every day she would make a posting about me.
Okay. And all around the same time frame of March of this year.
Yes.
Okay. All right. Well,
And I also do not believe that it's okay for someone who is in a nursing career to put my information about me being in Pine Rest Hospital out for the public because that is violating HIPAA regulations.
Well, certainly could, and you know, and I will say certainly, you know, that's the kind of information that qualifies as harassment, and that's you know, what about these protective orders is, uh, you know, the essential goal of the protective order is to keep the two parties apart from each other so that things don't escalate to being, hey, meet me at such and so an address, and they turn into a fight or a gunfight or a knife fight or anything else. You know, the law's desire in this thing is, I sometimes say it's kind of like a boxing match or you know, a kickboxing match where the referee says to the two people that are fighting, hey, you two get back to your corners and you just stay there. No swings at the other person. You know, just stay in your corner and let this thing cool off a little bit. And, you know, that's what, anyway, we hope they do. And, you know, it sounds like it might be working here, but the facts that were testified to today before the court and establish that, you know, on or about early, late February, early March of this year, that there was an exchange, maybe several exchanges between the parties here on various electronic platforms, including, you know, apparently Instagram and Facebook. And the plaintiff responded by, or the petitioner here, Ms. Gonzalez replied by filing a request for a protective order, stating that she had threatened me with her firearm and threatened my family. She has found where I live and has been posting my address on social media. And just now she's been texting me and told me she is outside my house. I do not feel safe, especially when I've been threatened countless times with her firearm. And to support that, yeah, the court was shown messages today that did indeed say, you know, threatened to take you off the map and know that I carry two, which, you know, perhaps in street language, certainly, you know, when we refer to carry, I take that as perhaps you're exercising the ability to carry a concealed weapon and doing so. So, given those messages and then subsequent messages that do say Stank needs a whooping, with a picture of the house where the petitioner, Ms. Gonzalez, lives, I certainly can see where, you know, in a reasonable person's mind, that would be considered threatening. Now, Ms. Gamboa has appeared today and supplied additional messages to the court and also a letter saying basically I'm not maybe the crazy person depicted by these exchanges here, but rather, Judge, I want you to understand this was in the context of a mutual exchange online where things got heated on both ends. And I agree that it was. However, I do have to recognize that Ms. Gamboa, it was you that escalated this, you know, with saying you carry, you know, implying a weapon and also posting the address, which I didn't see in the other messages that you posted that, you know, she was outing your address or doing those things. There were threats, you know, back and forth and shut up and name calling and things like that going back and forth, but not, you know, it escalated when there's a threat of a weapon. So I do think that two incidents occurred online in this case that would justify continuation of the protective order as it's written. And after all, protective orders don't, you know, they're not major limitations on your life except with regard to the protected individual. And secondly, with regard to purchasing or possessing a firearm, they do limit your ability to have a firearm in your possession during the time that the protective order is in place. And because the threat here is about carrying, I'm inclined to leave that firearm provision in here. So I am going to allow the protective order to continue at this point. As I said, I write these for 6 months, and this one therefore expires, I think, in September, or the expiration portion of it. Yeah, expires September 3rd of next year. So this will expire about coincidental with the start of that nursing program. I would counsel you, Miss Gamboa, you do seem to be, a person who thinks about the future and things like that. This falls into a broad category of things that are simply not worth it to mess with the protective order while it's in place. Just the definition of contact in here, because it does say you can't uh, uh, contact the person by telephone or send mail or other communications to the petitioner. While the definition of contact is very broad because it references another Michigan statute, which basically says if you post on social media or if you send something to someone else on social media and they're going to forward it to the person, with the intention of getting their attention, that can be construed by me as you contacting them. And the way that happens, if um, Ms. Gonzalez feels like you violated that by something that you posted or something stated online, is that she would bring a alleged violation in front of the court, and then you'd be entitled to a hearing as to whether or not whatever was posted did violate my protective order. And I always tell people, and if I do find that you violated, the penalties there are up to 93 days in jail and a $400 fine. So it's way easier just to say, okay, we're going to take that neutral corners at this time and not have any contact with each other. Sometimes these people that file these live like, you guys aren't like neighbors, are you? Like not right next to each other, or I mean, I do know
No.
you both have Northwest addresses, but it doesn't sound like you would run into each other every day walking your dogs or anything like that. So, I tell most people it should be pretty darned easy to obey the terms of a protective order, because it basically says, obey the law. Don't pester this other person for 6 months. And as it comes up to that 6 months, if Ms. Gonzalez feels like there is a basis for continuing the protective order, and that basis the law defines as another violation of the protective order that occurred between now and then you can ask to extend it, or it just automatically expires and I remove it from the lien system and it is no longer an issue. So that's what I think both parties' goal ought to be here. There was a online blow up. Fortunately for everyone, it didn't result in any sort of physical confrontation or anything else, because it's always worse. And I always applaud parties for turning to the court and saying, hey, you know what, I'm angry about this, but I'm going to handle it essentially by filing some paperwork rather than by actually going to your house and knocking on your door in the middle of the night or something along those lines. So it is a preferred way of resolving things, even though it's not perfect. So any questions from me from either petitioner or respondent? I'll give you the first chance, Ms. Gonzalez.
So, I guess just one confirmation that the PPO will remain in place.
It will remain in place till September 3rd of this year.
Okay, thank you.
Thank you. And Ms. Gamboa, any questions for me at this time?
No, I just want to reassure you that I did not make any contacts to her since I received the PPO order. I just
Good.
want to make
No.
that very, very clear.
No, I appreciate that, and I don't have any allegations that you violated yet, and of course those would all come up after you've been served, and you identified that service date as March the 9th, so that's when that takes effect regarding you, is when it's actually in place. And I'm grateful that you didn't, like I say, you've got everything to lose the way the PPO works if you violate. So even if something does bother you, or you think someone's trying to get under your skin, always best to just document it so that if we have that hearing to continue, you can bring that in front of me, but don't respond to it. I know it's a hard thing to ask, but nonetheless, I try to make these fair for all the parties, and that's my goal here. And simply, keep everyone safe is a important second goal. So that's what we're trying to do. I appreciate both of you showing up and speaking very clearly on your own behalf and bringing in evidence today. That was very helpful. So thank you very much. Both of you have a safe weekend. And like I say, it will remain in place till September, upon which it'll expire unless Ms. Gonzalez submits ahead of time for an extension.
All right. Thank you, Your Honor.
Thank you all.
We are here in the matter of the people of the state of Michigan versus Thomas Parm, case number 26-01466-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on a motion for bond, and I would invite counsel to place your appearances on the record.
Tiffany Burks on behalf of the people.
I'll make down on behalf of Mr. Parm, Your Honor.
Very good. Thank you, Mr. McDonough. And let's see, we're asking for a lift of the no contact order with sister to return to work. Do the people have a position on the modification of bond, Ms. Burks?
Your Honor, the people believe that the bond is appropriately set at this point in time with that no contact order.
Okay, you'd like to leave the no contact order in place.
That is correct, Your Honor.
Have you had any input from the victim here, the sister?
We have not at this time, Your Honor.
Okay, Mr. McDonough, what's your, usually my policy when there's a no contact order involving the victim in a case like this is I require the victim to appear and either one hand submit an affidavit, but even more preferable than that, I prefer the victim to appear to hearings such as this to swear under oath that they want it lifted. Is the sister prepared to do that at this point?
I do not have her lined up to testify today, Your Honor.
Have you had contact with her to know?
I have not. I've had contact with the client and with the father. It's a family-run. It's a shop, a car repair shop on the west side. Family-run business. She handles office work, and Mr. Parm handles the sales. They do work in somewhat close proximity, but they don't work together. And I know that the father, David, the owner of the business, really would appreciate having Mr. Parm there to handle all his responsibilities. Having said that and understanding what the court would prefer, I mean, I can see if I can get a hold of an affidavit and or set it up for another hearing if the court's willing to entertain one.
Okay, well, and you know, I'm looking at this. Okay, let's see. Child. He was arrested, passed out.
Oh, that was the case for which he's on probation with you.
Oh, okay.
What we're dealing with now is a new case.
A new case. Okay.
Your Honor,
Yes.
if I can just add to the people's concern here. So Mr. Parm picked up an OWI charge. I believe it was late last year, and then shortly after picked up another OWI charge with his son in the vehicle. And now we're seeing that Mr. Parm is continuing his, I would call it concerning conduct at this point in time, by now using a weapon on family members. The people are just concerned that his behavior is escalating, and I'd hate to see what would happen next if he's not kept in check, at least with a no contact order.
Yeah, no, I would tend to agree with that assessment. I would much rather, in a case like this, err on the side of caution than, given the concerning behavior. And just thinking out loud, it seems like the request here isn't necessarily for a full lift of the no contact order, but perhaps just a lift at the workplace. However, if the sister's full-time employed or at least part-time employed at the workplace, she might not, if she's the victim here, she's the victim, correct? That's why there's the no contact?
We're working on that. The way things are structured now, I do not believe that the felonious assault is going to maintain a charge.
Yeah,
I do not believe
but I
it.
mean, as things stand currently, you're right. She's the at least alleged victim, and that's why the no contact is in place and probably put in place by the district court, not necessarily by me in the first place. Is that all accurate, Ms. Burks?
Yes, Your Honor.
Okay, well, here's what I will do for the time being is I'm going to deny the modification at this time of it to lift the no contact order. However, if the sister is willing to agree to a limited lifting of that, and she could indicate that to the court either by a signed affidavit or by appearing at another bond hearing, similar to what we're doing here today, and testifying to that, then I would be willing to grant a limited lifting of the no contact order for the purpose of employment, if the sister's comfortable. Because as I said, my policy with these is to defer to the victim or alleged victim in this case, since it hasn't, gone to trial yet. So what I'll do is deny it for now, but the path forward, Mr. McDonough, if um, is to get some sort of assent from the victim here, because that's my policy. So
Understood. That makes sense. So am I to understand then that my submission of merely just the affidavit would operate to trigger that limited lifting,
yeah,
as
that's
opposed to setting it up for another hearing a month from now? Or
no, fair enough, and right, understanding his desire to get back to work, and frankly, my lack of knowledge as to whether this would be a massive problem contacting the sister at work, or whether it would be a non sequitur, as they say
Okay.
sometimes. So yeah,
Very
that's
good. Well,
Mr. McDonald, thank you.
yep.
Your
Thank
Honor,
you
could
all.
I ask a just kind of a procedural question here? So Your Honor handled the last case for Mr. Parm, and then I saw that this case was assigned to Judge Mims. Is this court taking the case back?
Oh, the current case with the no contact order is assigned to Judge Mims?
Yes.
It was, and then a reassignment was prepared by the clerk's office.
Okay,
Okay.
to me, yeah, it seems like it should be to me. There seems to be something amiss in our, I've noticed that several cases that, where the defendant's on probation to me and they're going to other judges, and I don't know what altered or changed, in our, case defendant following the judge while they're still on probation, et cetera, type policy, but something seems to be amiss at our clerk's office. But I'm trusting that eventually the cases that are supposed to be in front of me will get back in front of me. So,
Okay, thank you.
Okay. Thank you all.
and this matter comes before the court today on a motion to modify the bond. Counsel, would you place your appearances on the record, please?
Tiffany Burks on behalf of the people.
Morning, Your Honor. Don Smith on behalf of Dr. Mayer.
Very good. Thank you, Mr. Smith. And reading this, right, it looks like the no contact order is what's the modification of the no contact order? I didn't see that, Mr. Smith.
We made 4 requests in our motion. The last one is to allow him contact with his wife, who is not a listed victim in this case.
Okay. All right. Well, what I will do in this matter, the request here is for attendance at the funeral, absolutely reasonable. Travel to Indiana, also reasonable. We'll permit that. I will remove GPS monitoring. Dr. Mears done great, and complied with the requirements there, and certainly thereby has established that he can be trusted with regard to following the court order. The modification of the no contact order, I will permit it. However, under the condition that any contact with the alleged victim be in the presence of another adult. That it not be unsupervised contact, in other words.
Your Honor, can I seek a clarification of that?
Yeah, go ahead, Mr. Smith.
All right. So in this case, he's alleged to have last summer, so basically 9 months ago, he's alleged to have caused bruises on his oldest daughter. He has 3 children, 12, 10, and 8. The no contact order presently prohibits him from having contact with any of his 3 children, nor his wife. And he obviously wants contact with all 3. And it sounds like you would say he can have contact with basically all 4 of those protected parties. I think that's what you just said.
Yeah, and that's what court services indicates there. Let me hear from Ms. Burks. Ms. Burks, any input from the victim side in the matter?
Your Honor, we did receive a letter from the victim in this, well, not the victim, but Miss Mayer in this case, indicating that she wants the no contact order lifted as it pertains to her. I would also support the court's decision to have any contact with the kids supervised by an adult during the pendency of this case.
Very well. Yeah, no, I'll clarify that. And thank you both, counsel, for focusing me. I've got a stack of these, of course, 6 high here, and sometimes I get them a little crossed as to what I'm trying to accomplish. And what I think that's very reasonable. Let's lift the no contact order with regard to Dr. Mayer's spouse, and also with regard to the children, with the caveat that any contact would be supervised by another adult present. I think that adequately, protects the, purported victim in the matter, and, ensures the court's interests. And of course, since I've lifted it with regard to the wife, if Dr. Mayer and his wife and the children are all present, then that's an acceptable situation as far as the court's concerned.
Great. Thank you very much. Your Honor, would you like me to prepare an order, or is that something?
If you would send over an order, Mr. Smith, because just like I have a hard time keeping these straight before I get into the hearings, it's even harder to keep them straight following afterwards to remember what I ordered. So if you would send me an order for my signature, that would be greatly appreciated.
Very good. Thank you.
Thank you.